Hello, everyone, and welcome to Adelante. Today, I have the opportunity and great honor to have a conversation with Erwin Chemerinsky, Dean of UC Berkeley's Law School and a national leader and scholar in constitutional law, and a good friend of the ACLU, who pre-COVID used to present at all of our national staff conference. So can you tell us a little bit about the cases that are before the Supreme Court this term, and those that the ACLU supporters should be keeping an eye on?
This is likely to be a blockbuster term in the Supreme Court. Got to start with abortion. The Supreme Court on November 1st heard oral argument in two cases involving Texas anti-abortion law, SB8. It prohibits abortions after the 6th week of pregnancy. It's not enforced by the Attorney General or district attorneys. It's enforced by civil suits against doctors or those who aid and abet abortions. In the two cases that were argued that day, Women's Health versus Jackson and the United States versus Texas, involve procedural questions. Who can sue to enjoin such a law? On December 1st, the Supreme Court's can hear oral arguments in another abortion case. This is Dobbs versus Jackson Women's Health. This involves a Mississippi law that prohibits abortions after the 15th week of pregnancy. In Roe versus Wade, 1973, the Supreme Court said a woman has a right to an abortion until viability, the point at which the fetus can survive outside the womb. In 1992, in Planned Parenthood versus Casey, the Supreme Court said it was reaffirming the essential holding of Roe, that a state can't prohibit abortions before viability. Science and medicine tell us that viability is about the 24th week of pregnancy. The Mississippi law prohibits abortions after the 15th week of pregnancy. What concerns me is I can't count 5 votes on the current court to strike down the Mississippi law. Justices Thomas, Alito, Gorsuch, Kavanaugh, and Barrett, in their writings on the bench and off the bench, have been sharply critical of Roe. The court might uphold the Mississippi law, but leave open what about laws that forbid abortion earlier, like Texas, Iowa, Ohio, that forbid abortion after the 6th week of pregnancy, or Alabama that prohibits abortions after the moment of conception. Or maybe these conservative justices will use this as the case to overrule Roe versus Wade.
Are there other issues on the docket that are particularly important from a civil liberties perspective? I know there's a FBI infiltration of a mosque and gun control, other issues. What are your thoughts?
Sure, I'll take those two and then one more. There are a couple of cases that involve the so-called state secrets doctrine. This says that federal courts can't hear certain matters if it might lead to revealing national security information. And there are a couple of Supreme Court cases that involve, well, when does the state secrets doctrine keep a federal court from hearing a case? There was a case argued in the Supreme Court, an ACLU case, that involves some Muslim individuals challenging the FBI's infiltration of their mosque. And the question is, did that have to be dismissed on account of the state secrets doctrine? There was another case that was argued in October that involves an individual who was apprehended and taken to a site in Poland where he was tortured. He's been held in Guantanamo for many years since. And the question is, can he obtain information related to his torture in Poland as part of a suit that's going on there? Or does the state secrets doctrine preclude that? You mentioned guns. The Supreme Court heard oral arguments on November 3rd that involve a New York law that prohibits having a concealed weapon in public unless a person has a concealed weapons permit. It's a law that's over 100 years old. What's interesting is from 1791, when the Second Amendment was ratified, until 2008, not once did the Supreme Court declare unconstitutional any federal, state, or local law regulating guns. Not once. And then in June 2008, in District of Columbia versus Heller, the Supreme Court said the Second Amendment protects the right to have guns in the home for the sake of security. But the case that was argued on November 3rd, New York Rifle and Pistol Association versus Bruin, involves whether there's a right to have guns outside the home. and whether there's a right to have concealed guns. If I could add one more case, important from an ACLU perspective, this concerns separation of church and state. It's Carson versus Macon that'll be argued on December 8th. For decades, the issue in litigation before the Supreme Court and lower courts was, when may the government give aid to religious schools without violating the Establishment Clause of the First Amendment? Can the government give audiovisual equipment, sign language interpreters, buses for field trips to religious schools? Or is the government doing that constitute an establishment religion? Now the question is, when must the government give aid to religious schools, or it violates free exercise of religion? Carson versus Macon comes out of Maine. There are areas of Maine that are too rural to support public schools. So there's school administrative units that give money to parents to send their children to private school. The money can be used for any secular private school. A couple of religious schools, a couple of parents are arguing that to deny the money going to religious schools violates free exercise of religion. Or put it another way, they're saying the government is constitutionally required to subsidize religious education.